Representative Danny, House Bill 46.
Thank you, Mr. Chairman. I have before you the House Agriculture and Water Resources Committee substitute for House Bill 46. And it's relating to agriculture providing protection for farmers from liability over possession of genetically engineered products and providing court jurisdiction for infringement cases. Really the heart of this bill and the reason for this bill is because Congress, in Congress's infinite wisdom, has decided that genetically modified genes are patentable products. And much like a sewing machine or a steam engine or a computer, and that, and as a result, all the patent law applies. Now, it's my understanding that patent law does not allow for possession of that product without a license from, or somehow a grant from the person that holds the patent. Now, the problem with this is that a gene is a living thing. It's not like it's not a machine or like a computer or a sewing machine. It's a living thing. It can move by itself. So, for instance, a gene that would be in say a bean plant that's pollinated by insects can be moved from one plant to another, from one field to another, from one state to another, for that matter. Or the wind can move pollen around. So this gene can move around by itself, so the heart of the bill is that it says in section B on page 2, line 18, if a genetically engineered product in which the manufacturer has a patent right is found in de minimis amounts or found to be unintentionally on the property owned or occupied by a farmer, the farmer is not liable to the manufacturer. And to me, that I've always learned that a person is innocent until proven guilty, and I think that this bill is consistent with that legal principle. Let me give you an example of what might happen. I used to be the manager of a farmers cooperative, and we had thousands of acres of beans and wheat in Dove Creek, Colorado. Now, beans are a product that can be moved by pollinated by insects. So if the bean plant was on this field, and let me tell you about our bean plants, by the way. They were kind of like what they call a land race. They were not developed by a college, agricultural college. They were just beans that people had planted there and had been able to produce over the years in a very tough environment, very, very tough environment, maybe 12 to 15 inches of rain each year. And but because of the type of soil, the kind of clay soil that was there, and the farmers were able to deal with that droughty conditions almost every year, they were able to, and because of the quality of the beans and the type of beans they were able to grow beans in situations where maybe they didn't get any rain at all. They could make a crop of beans, although not a very good one, just on snow melt. And so we, as a farmers cooperative, we would take these beans into the elevator and credit the farmer for his beans. We try to pick out the best beans for seed, and then the farmers would come and get these seeds again and to plant, and we would give them back and credit and debit their account for beans and charge them for the processing, cleaning, and so forth. Now, if it's my understanding that according to patent law, if some of that gene had gotten into our seed, then we'd be in violation of the patent. And in which case it would just about shut down our seed production. And the bean, that specific bean that was, specifically bred and developed by those farmers for that area would have been illegal to use for seed because it would possess that gene. So this is what this bill attempts to address. And would Ms.